Most green card holders think that filing for citizenship is simple. Wait 3 or 5 years, then boom, file your application. But in 2026, simply filing the N400 is not enough. Knowing when to file is not enough. You also need to know exactly what will happen, because underneath the Trump administration, citizenship is now being handled differently. USCIS is simply not just looking at your eligibility date. They're looking at a lot more, starting at the moment your application lands on their desk. So I'm going to show you when it is actually safe to file for US citizenship, the timing mistakes that could cost you your case, and the full citizenship timeline in 2026, step by step. So you know exactly what to expect along the way, because applying at the wrong time or not knowing what is going to come next could cost you months and sometimes years. And this video will help you avoid that. So before we talk about timelines or what could go wrong, you need to know the exact moment that USCIS will even allow you to file, because filing too early or too late can sometimes create problems that most people don't see coming. For most green card holders, there are really only two timelines that could apply when deciding to file the N400, the 5-year rule or the 3-year rule. But these labels are a little bit misleading because USCIS does not just count calendar years. The 5-year rule applies to most green card holders, no matter how you got your green card, whether through family, through VAWA, or through something else. Here is the key detail that trips most people up. USCIS does not count from the day that you enter the United States or even the day that you file for a green card. They count from the resident since date on your green card. This date, which is printed on your actual card, controls everything. If you file even 1 day too early, USCIS can end up denying your application, and this would cause you to lose your filing fee. Now, some people can qualify earlier underneath the 3-year rule, but this rule is actually much stricter than people realize. To use it, all 3 of the following things must be true in order for you to benefit from the shorter timeline underneath the 3-year rule. First, you must have been married to a United States citizen. Next, your spouse must be a U.S. citizen for the entire of the past 3 years. And 3, you must be living together in marital harmony and union at the time of filing. To utilize the 3-year rule, it does not matter how you got your green card as long as you can meet these 3 rules. And these 3 conditions must overlap perfectly. So if there is a separation, a divorce, or even a timing mismatch, then this rule will not apply. And you are pushed back to use the 5-year rule. Now here is where people usually think that they're eligible, but they get pushed back and delayed by years. Because even if you qualify underneath the 3 or the 5-year rule, you still must meet additional requirements. And not meeting these in a timely manner can end up delaying your application sometimes by as much as 4 years. Let's start with physical presence because this is pure math, and USCIS does not bend it. If you are applying for the 5-year rule, you must have been physically present inside the United States for at least 30 months or 913 days. And this must occur within that 5-year period before you apply. And if you are applying underneath the 3-year rules, then you must be present for 18 months or 548 days. And this must occur within the 3-year period before you file. Here's the part that people underestimate. If you are even 1 day short of physical presence, then you would not qualify. USCIS does not give you credit for being close enough. And this is where frequent travel can cause a problem. You can hold a green card for 5 years, but take just one more trip that takes you outside of this physical presence rule, then your application will get denied. And your eligibility can shift by sometimes years. Now, physical presence is how long you were in the United States. Continuous residence is really about whether USCIS believes that the US is actually your home. And this is also where travel can break your continuous residency. Here is how USCIS looks at it. If you have taken any trips outside the United States, they will look to see whether you have taken any trips that are more than 180 days long outside of the US. So if your trips are usually underneath 6 months, then you're probably safe. But if you have any trips that take you out of the US for 6 months or more, USCIS may presume that you have broken your residency. And especially if you have been outside the United States continuously for more than 1 year, then USCIS will definitely say that you broke the continuity of your residency. If your trip has been out of the US for less than 1 year, here are some ways that you can still try to fight the presumption that you have broken your residency. You can show things like the fact that you still own a home inside the United States, that you returned to a job that you previously held, that you continue to file taxes as a resident, and that your close family is still here. This is not a list of exclusive factors, and you can try to use a combination of other things to show that you never left the US as your home for a permanent reason. But once your trip hits 12 months or more, this is automatically going to be considered an automatic break in your residency. And when this happens, you will have to wait another 4 years from the date of your last return to the United States. And this is the part that USCIS does not explain. Even if you never take a trip that is more than 12 months long, a continuous pattern of trips that last exactly 6 months out of the United States for the period of time that you are a resident can still raise a red flag about whether or not you are actually a resident of the United States. So for those of you who maintain homes abroad, this can be a problem for you. They're going to look at your travel history as a whole and not allow you to play it having it both ways. In addition, there is something called the 90-day rule. USCIS allows people to file for citizenship as early as 90 days before they become eligible. That means if you qualify underneath the 5-year rule, you could submit your application as early as 4 years and 9 months. And if you qualify underneath the 3-year rule, you can submit your application as early as 2 years and 9 months. This is not a loophole, it is an actual USCIS policy. But here is what most people do not understand. Filing earlier does not make you a citizen sooner. It simply just gets your case into the system sooner, and in 2026, the wait time is getting longer. Processing times are increasing across the board, and interviews are backlogged. Once your application is pending, you are subject to any rule change that may apply. But for many people, filing at the 90-day mark is a safe bet. But it's also where people make a mistake. If you file even 1 day too early before your 90-day period starts, then your application will also get denied. They can even just reject it outright. And in this case, USCIS may not refund your filing fee. That is why USCIS provides to you an early filing calculator, so you know exactly when is the earliest day that you can file your application. I'll include a link to that in the description below. So if filing early can protect you, how come everybody doesn't do it? Because filing early is only smart if your case can survive the scrutiny it will receive. Filing at the 90-day mark is a smart move if your case meets all of the requirements easily, meaning your travel has been consistent, your taxes are filed and up to date, and there's nothing unresolved in your record and no issues with your physical presence or continuity arguments. Filing early can help lock in some of these eligibility requirements, but keep in mind, you must continue to prove your eligibility on a rolling basis up until and through the date of your swearing-in ceremony. So filing early may not be the right move for everybody, especially where you may lack in one of these categories. And if there is anything unresolved in your background, you should certainly get it resolved with the assistance of an attorney before you file, before it creates more complications in your case. Some of these examples of complications could include the fact that you have taken long trips out of the US that are close to the 6-month mark and are still recent enough to raise questions about your continuity of residency. You are still fixing tax problems, missing filings, or setting up tax payment plans. You have had a recent arrest, court date, or hearing, and this is true even if there is no conviction. You are applying underneath the 3-year rule, but you are separated or divorced from your spouse. You have moved states recently and do not match the 3-month state residency requirement. You have had inconsistencies between past immigration filings that you have not yet reviewed or corrected. In these cases, filing early can actually hurt you. And that is why it is important to know about these little nuances. Now, in just a moment, I'm going to take you through the actual timeline for when you file step by step, so you know where slowdowns can come from and what to expect during the course of your application. But first, I do want to let you know that we are accepting new clients. My name is Mamita Rahman, and I have been practicing immigration law for the past 15 years. If you would like my help on your citizenship case, give us a call at 212-248-7907. We are based in New York, and we help clients all over the US. Okay, let's start with what happens the moment that you file your N-400 application. Once you have filed for your N-400, your citizenship case officially begins. You can file your application online or by mail. Most people file online because they believe it will reduce basic mistakes, it gives you immediate confirmation of your filing, and it lets you track your case in real time. Paper filing is still allowed, but it's a little bit slower and more likely to get rejected for missing pages or outdated signatures. As of 2026, the filing fee is currently $760, whether you file online or by mail. And if your case gets rejected or denied, you will not get refunded your fee. Now, timing matters here. If you file online, you will usually get confirmation right away, and your receipt notice is usually issued within 1 to 2 weeks. If you file by mail, the receipt notices usually take 2 to 4 weeks, and sometimes longer depending on USCIS delays. At this stage, USCIS is not deciding your case yet, but you may get rejected if you file 1 or 2 days too early, you choose the wrong eligibility category, you're missing a signature or an answer, or you submit information that may not match prior immigration filings. If your application is rejected, that doesn't mean a denial, but you could lose your filing fee, you would lose your place in line, and you would lose the time that you have spent up until then. But if your application is accepted and not rejected, then you will be issued a receipt notice. And this is when your case officially moves into processing. The next step is biometrics. This is where USCIS collects or sometimes reuses your fingerprints and your picture and signature so they have it on file. They will use this to run background checks and also to verify your identity. In most cases, the biometrics appointment is usually received about 6 weeks after the receipt notices are issued. Sometimes, though, they will not issue an appointment at all. If you have some biometrics already in the system from a prior application, USCIS will sometimes elect to use that instead. And you would receive a notice saying that you do not need to appear in person and rather that your biometrics will be reused. For the biometrics appointment, you will be asked to go to a local application support center where they will take your fingerprints and picture, and you'll be done in about 15 to 30 minutes. This is when USCIS's clock really starts running. They will conduct FBI fingerprints, criminal history searches, and other background screenings to determine if there are any eligibility factors. They will use this to pull prior filings and to see what else you have filed. And here, if there is anything in your record that does not line up or add up, such as old arrests, mismatched information from previous filings, name variations, or past immigration issues, this is where USCIS will begin to take note. If you missed your biometrics appointment but you do not reschedule, then this can definitely result in a delay. So this step is important for you to make sure you attend. After the biometrics are issued or reused, most cases enter the quietest and the longest period of time. This will be the waiting period before you get called for your citizenship interview. For most applicants, the citizenship interview notice is issued about 4 to 10 months after biometrics. In high volume cities, it could take even longer. And during this time, it could feel like nothing is happening, but it's simply not true. During this time, USCIS will finish their background checks, review your full application, compare it to previous filings, and decide whether or not your case can move forward cleanly or whether it requires extra review. This is also where cases could slow down due to the extra scrutiny. But once USCIS is ready to move your case forward, they will send you an interview notice by mail or post it to your online account. This notice will tell you when and where your application's interview will be and what you should bring to your interview. On the day of your interview notice, USCIS officers will review your entire N-400 filing and put you underneath oath. They will not just test you for your knowledge of English or civics. They will verify everything you've placed and try to understand whether you are actually eligible to be approved for citizenship. This is when USCIS will ask you about your travel history, your work and address history, your taxes and financial obligations, and any arrests, citations, or other encounters with law enforcement you have ever had. And it will also ask you about past immigration violations. If you have ever filed for other things in the past, they may ask you about discrepancies between the applications. If you were applying underneath the 3-year rule, it will verify whether you and your spouse are still together and still living together as well, because they need to make sure that you are still eligible underneath this rule. You will be administered the English and civics exams unless you qualify for an exemption. The interview can typically last 20 to 40 minutes, but the preparation time behind it is really what matters most. If you want to learn about what to expect at the interview, I have made a separate video outlining step-by-step what to expect and what questions you may be asked. I'll include a link to that in the description below. At the end of the interview, usually one of 3 things happens. You may be approved on the spot, you may be told that a decision is pending further review, or in some cases, you may be asked for additional evidence. All three outcomes are common, and none of them mean that your case is over at that moment. If a decision is not made at the interview, USCIS has a 120 days to make a decision. During this time, this is when a request for evidence may be issued, and USCIS may ask for documents that they believe are missing or that are needed to clear up eligibility factors. Getting a request for evidence does not automatically mean a denial, but it will mean a little bit of a delay. Now, even after you're approved after your interview, you're still not yet a citizen until you attend the swearing-in ceremony and take the oath to become a citizen. Becoming a citizen only happens once this oath is complete. So after you are approved at the interview, USCIS will send you a separate notice for your oath ceremony. In many cases, this will usually take anywhere from 2 to 6 weeks to receive. If you have elected to change your name, then usually your oath ceremony will have to occur in front of a judge, and the scheduling for that may be a little bit longer. But if you are wanting to change your name, I recommend you take advantage of the simple name change system through your application because it's much easier than going through civil court. Some USCIS offices also offer same-day oath ceremonies, but these are the exception and not the norm. And again, if you are electing to change your name, then you would have to go through the judge. Your oath ceremony notice will tell you the time, date, and location of your ceremony and what documents to bring with you. And remember, you still must continue to prove eligibility up until and through the date of your ceremony. So this means that if you take that one trip that removes you from physical presence requirements, or you get arrested for something that becomes a disqualifying crime, then you may not be able to complete your ceremony. At the ceremony, you will take the oath of allegiance, turn in your green card, and receive your certificate of naturalization. The ceremony itself can take anywhere from 1 to 2 hours, depending on how busy this location is. But this is the moment you have been waiting for. This is the moment that you become a citizen. And from this day forward, you are now a citizen and have all the rights that will be accorded to you by law. Now, if you are planning to apply for citizenship or have already started the process, you also need to know what to do the moment you become a U.S. citizen. There are several steps that you should take right away, and missing even one of them could create problems later. I've explained each one of them in my video, the top 7 things to do after becoming a U.S. citizen, which has already helped more than 1 million people. I walk you through exactly what those steps are, the order in which you should do them, and the mistakes I see new citizens make all the time. I'll include a link to that video here, so click now and I'll see you there.